This program is brought to you as a public service by Maui Causes. Maui Causes is a crowd-funded media production group that provides media production services to a variety of environmental and progressive causes here in Maui County. Visit us on the web at www.mauicauses.org.
And members, we are on IAM 32 relating to subdivision deferral agreements. And we have with us today Mr. Sam Small from Maui Causes. The chair will designate Mr. Small as a resource person pursuant to Rule 18A of the Rules of the Council, and he has special expertise in the subject area. Mr. Small is the executive director of Maui Causes, a crowd-funded media production group that supports progressive and environmental causes in Maui County. And members, as indicated in documents provided to this committee from Corporation Counsel, the portion of the code relating to deferral agreements, section 18.20.040, existing streets, has been amended a number of times over the years. So in essence, subdivision deferral agreements have allowed improvements to existing streets to be deferred or exempted upon subdivision under particular circumstances, depending on which version of the ordinance was in place at the time of the subdivision. So at our last meeting, when discussing Hui Road F, the Director of Public Works described improvement districts, which are a stipulation in certain deferral agreements, and a number of existing deferral agreements on that street in particular. This again reignited discussion relating to subdivision deferral agreements, and due to this, I would like for us to receive an overview presentation today to help us understand the multifaceted nature of the issue. And at this time, we will be receiving a presentation from Mr. Small concerning deferral agreements. And with that, Mr. Small, the floor is yours.
Thank you, Ms. Cochran, for your invitation to speak today. As always, it's an honor to participate in the democratic process, and I'm happy to share the fruits of Maui Causes' extensive research into a documentary that we are making on the contributing factors of Maui's shoreline degradation. Anyone interested in learning more about this documentary, please see me after. We're here today to talk about the 3 lot-or-less subdivision infrastructure deferral agreements. Let me start with a quote from the cover story published in Maui Time Weekly. The war, their words, the war in Maui County over deferral agreements is raging again. It flares up now and then through the years, only to dissipate a few weeks later. Silent for the last couple of years, the issue began getting discussed a few weeks ago. In fact, county officials are insisting that the problem may even be coming to an actual solution. The problem is that was written by Anthony Pignataro in January of 2013. That's over 5 years ago. It's back. Let's look at what's happened recently that's caused this issue to flare back up and see if we can find some ways to help solve these problems. On January 8th, Public Works proposed the creation of an improvement district for the substandard roadway Hui Road F in West Maui, which in part involves collecting on several 3 lot or less subdivision infrastructure deferral agreements as a funding source. So collecting on deferral agreements along Hui Road F is on the front burner. Public Works' proposal is historic. Not only has the county never once collected on any of the thousands of deferral agreements that it has written since 1974, this is the first time that Public Works has publicly addressed the unpaid agreements since 2014. In December, the council unanimously approved Mr. Guzman's resolution urging that the independent county auditor audit the Department of Public Works and make specific determinations needed so the council could move forward on county business. Unfortunately, that audit won't happen soon enough to address Hui Road F in any kind of timely fashion. The council stated it needs determinations on the number of agreements that actually exist, the parcels involved, the capital improvement projects that impact the parcels involved, the different permutations of deferral agreements that exist, and their collectivity related to the CIPs already completed as well as future CIPs. It's a lot to look at. The resolution included a partial history relating to the agreements, and I'll brief that. They were created in 1974. No one knows how many agreements were written between 1974 and 1990. Prior to 1990, the ordinance was silent as to whether subsequent subdivisions of the resulting lots could also defer their infrastructure improvements. In 1990, it was made clear that they could not. The land so divided shall not thereafter qualify for this exemption with respect to any subsequent subdivision of any of the resulting parcels. A one-time event. That's really important. Please remember that. No one knows how many agreements were written between 1990 and 2007, when the 3 lots or less deferral agreements were eliminated by the council. In 2015, the Upcountry Water Bill fully exempted 2 lot or less subdivisions from having to make any improvements on existing roadways or from contributing any prorated share to any future county roadway projects. Complete giveaway. The exemption was added into the Upcountry Water Bill at the very last minute. There are a few relevant county actions that the recent auditor resolution did not reference. In 2010, the council addressed the fact that the county had never actually collected on any of these agreements and said it changed the language. When and if was replaced with shall. No, it says on the bottom, you read that bottom paragraph, notices of intent to collect shall be sent to property owners bound by the deferral agreements upon commencement of funding and frontage land acquisition. It's 2 notices. Responding to the new ordinance, Public Works sent out notices of intent to collect to 14 landowners in West Maui with deferral agreements because the CIP that was 15 years in the making was finally scheduled for construction. That project was not shovel-ready. That's also an important concept. County records show that Public Works spent $1.2 million on that project without first acquiring the necessary land rights. Also unreferenced in the recent reso was the extensive 2012 proposed legislation to address these oversights by hiring a professional firm to form assessment districts and collect on the developer agreements. The bill also stipulated that all CIPs be shovel-ready, with all land rights secured before actual construction drawings get authorized. Council Services approved that proposed legislation as to its form and legality, and it was forwarded not to IEM, but rather to planning, where it was killed. Public Works Director told Maui Time Weekly simply that Corporation Counsel said the bill was not lawful. No further details were given. The differing legal opinions between the 2 legal authorities were never reconciled, and it's never been revisited. Also around 2012, Councilmember Cochran put forth an extensive effort to establish a formula and method of assessment and collection when Phase 4 of South Kihei Road was approved for funding. That hit a wall when Public Works wrote Member Cochran that we are unable to respond at this time as we are researching the applicability of certain agreements on the ability to seek compensation and working out a formula for compensation on certain agreements. Rest assured, they wrote, we are actively working on the issue. It's now 6 years later. They have still not revealed which agreements they were researching, They have not proposed any formula for collection, nor have they offered any determination as to whether any of the agreements can actually be collected on. In 2014, the Director of Public Works wrote in a Maui News Viewpoint, quote, "It's unfortunate that anyone would insinuate these agreements are invalid, secret, or a big pot of gold that the county is not collecting. They are agreements, plain and simple, and the county is abiding by them." He further wrote, "The Department of Public Works is currently enforcing the agreements as per their express terms." Well, in your deliberation over the auditor resolution a few weeks ago, Member Cochran mentioned that discussions about deferral agreements came to a standstill because of pending litigations. It really should be noted that there were no lawsuits involving deferral agreements until 2015. That's 3 full years after Public Works stopped responding to Ms. Cochran's requests for determinations. The lawsuits came because Corporation Counsel invited them. The administration has been silent, and so today, the public and this council really we're all stuck wondering whether Hui Road F or any capital improvement project island-wide can legally be initiated and performed without first resolving the question as to whether the various forms of these 3 lot or less deferral agreements can be collected on or not. In 2015, 2-lot subdivision exemptions, not deferrals, exemptions, further complicates the collection question. The stated intention of these 2-lot subdivision exemptions was to exempt only applicants on the upcountry water meter priority list, but we now know that the exemption is being applied to 2-lot subdivisions island-wide. For previously deferred subdivisions that actually only contain 2 lots, has their deferral now been replaced with an exemption? Either way, it's clear that the citizens will continue to pay for the impacts and improvements for private subdivisions. As the Hui Road F Improvement District contains multiple 2-lot subdivisions and overlapping deferral agreements, these questions really need to be addressed. The county needs to move quickly to avoid uncertainty and public outrage, and whatever is done here will set the precedent island-wide. Municipal standards and practices do exist to manage this process, and the council has already received proposals to get it all handled professionally. Understanding how all this evolved will help illuminate the systemic changes that are needed going forward so that Maui can mature as a modern municipality with healthy transparency and accountability. As I understand it, the intent of the ordinance was to allow parents to subdivide their properties for their kids and not face the immediate expense of performing infrastructure improvements like road widening, overhead utility relocation, storm drain structures, curbs, gutters, sidewalks, all that stuff. Instead, families could defer the cost of improving their subdivision frontage until the county performed an overall roadway project along that frontage. The owners simply agreed to pay a prorated share at some future date. The whole thing made a lot of sense. For years, the county didn't have an overall roadway plan, so putting in costly improvements along a relatively short frontage of a county road that will, in all likelihood, not match what the county did whenever it was that they would do it, would only end up getting ripped up and replaced. A lose-lose end result and a complete waste of millions of dollars of both public and private resources. So it made sense. By county ordinance, subdivisions of 4 lots or more specifically requires developers to install all condition roadway improvements to all or most of the frontage of their subdivisions. It's the exact opposite. 3 lots or less, you can get a deferral. 4 lots or more, no deferral. Absolutely, you got to do the work. And it's an easy question for a lot of people. Should I do 4 lots or more and pay a fortune on infrastructure now, or do I accept a one-time 3-lot or less limit and defer the costs now and maybe even pass those costs along to some future owners? Easy choice for a lot of people. It was a prudent and logical idea, but the original ordinance really wasn't well fleshed out. And subsequent revisions, though well-intentioned, have only served to make matters worse. The troublesome unintended consequences, and why I think we are here today, have come from what the ordinance didn't do. What's missing from the ordinance has spawned systemic loopholes that have been the key to the exploitation of Maui taxpayers and our environment for decades. Here's what I believe happened. The ordinance didn't provide for any guidance or oversight as how to execute the agreements or manage them over time. For decades, Corp Counsel wrote thousands of these agreements, recorded them with the Bureau of Conveyance, and then stored them in boxes and never referenced them again. Corp Counsel, Public Works, and Department of Finance have never successfully coordinated on cataloging them or collecting on them. Remember how these subdivision deferrals were supposed to be a one-time only event? That's the deferral part. If a lot is big enough, additional subdivisions can be added, but the ordinance restricted the new subdivisions from deferring, once again, the infrastructure improvements on the original subdivision's entire roadway project. If additional lots were carved out and added beyond the original 3, that would trigger the 4-lot or more subdivision requirement, and all improvements across the entire parent parcel must now be performed. It's a fair trade financially, since the original owner's value gets decreased by the increasing neighboring density, and the new developers benefit financially from being able to build. The cost of all the improvements on the entire parent parcel that were previously deferred, but now must be performed, those costs are to be assumed by the incoming developers. The intent of the original ordinance has clearly been obstructed by the fact that because the agreements were not cataloged and tracked, rather than adhere to the one-time only limit, Corp Counsel continued to write deferral agreements for subsequent subdivisions. Developers who knew how the system is flawed applied for and got sequential overlapping 3-lot or less deferrals that allowed them to subvert the 4-lot or more requirements. Mr. Good's map is from Hui Road F PowerPoint. You can see here that there are multiple numbers on certain parcels. Those are overlapping one-time deferrals on the same parent parcel. So it's TMK number -A, -1. Each one of those dashes is a subsequent subdivision. This becomes a problem when you actually go to try and collect. It's not the only problem, though. The ordinance did not put any limitations on the size and acreage of the 3 lots or less subdivisions. It didn't put any limitations on what type of subdivisions could take place on the resulting 3 lots. As you'll soon see, over the years, these agreements have been applied to commercial and massive residential and condominium developments, providing financial benefits to big developers far beyond the relief that was originally intended for local families. It leaves me wondering, is the new 2-lot or less exemption now being abused the same way? The original ordinance also didn't go into specific dollar amounts and provided no formula to calculate the future costs. It also didn't create any method of collection to complete the back end of the agreements. The agreements Corp Counsel wrote did get recorded and attached to the land's deed so that they would travel over time with the parcel, not the original developer or divider. That's also very important. Travels with the land. But with no value, formula, or payoff mechanism established on any of the agreements, they are open-ended, and there is no way for a property owner to satisfy and remove them from their title. On titles, the agreements show up in Schedule B as a non-specific cloud and encumbrance. They only become an actual lien if and when the county sends a notice of intent to collect. Remember, too, because this is important, we'll come back to it, notices of intent to collect. It gets very multi-layered. For decades, prospective buyers and mortgage companies have been told by attorneys, real estate brokers, and title companies not to worry about these agreements, simply and truthfully, because the county has never, ever yet collected on any of them, and that it's questionable that they ever will. When capital improvement projects that should have triggered collection did occur, and CIPs have occurred many times, the county has never collected from the landowners their fair share. One of the legal questions that Corp Counsel has not addressed, and maybe the auditor will, is whether, since the county did not pull the trigger at the time of a roadway project that was completed in the past, can they go backwards in time and try and collect now? How much money are we talking about? Let's apply the suggested assessment figures that Director Good sent to Councilmember Cochran back in 2012 to a typical 3-lot subdivision. We know they come in much larger shapes and sizes, but let's establish a minimum foundation for the magnitude of what's collected. So a little bit of math. Minimally, let's say a lot has 100 linear feet of roadway. That's like the width of this room. 100 feet at a cost of $250 per linear feet, which the Director of Public Works applied to developments along South Kihei Road. So that's $25,000 per lot. Who wouldn't cough up $25,000 to obtain an extra buildable lot on Maui? That's a gift. 3 lots would equal $75,000. Think you could improve 300 feet of roadway widening, drainage, utility locations, curb, gutters, and sidewalks for just $75,000? Again, it's a gift. Way low by real-world cost estimates, but we'll use it as our base. If there were 1,000 of these agreements, that's $75 million. Our research shows that the director's $250 per linear foot is way low. What you see on the screen is an actual estimate from an engineering firm using the county's specifications for a roadway project, which shows a number 3 times the director's estimate. If we use these numbers, the numbers mushroom, the loss to the county totals over $200 million. Keep in mind that we're talking about 100 linear foot as an average parcel. I know of developments up country that are 65 acres. That's a quarter mile of uncollected deferral agreements that gets absorbed by taxpayers. The public has and will continue to foot the bill for private developers' obligations. These 3-lot or less subdivisions are also completely exempt from having to pay park fee assessments, regardless of the size or assessed value of the resulting parcels. $1 million oceanfront homes, no park fees paid ever. Another huge giveaway of what would otherwise be the public's assets. The money owed from these agreements are revenue that is to offset the expenditures of public funds for projects approved during annual budget hearings. Our charter requires the administration to establish and track a 5-year projection of anticipated revenues for future projects. But because the administration has not cataloged the agreements, even if we went with the director's $250 per linear foot, no one knows how many roadway feet we're talking about. The county has no idea how much money is missing every year from the annual budget, which the council is asked to approve. That the owed amounts are not included as a line item in the annual budget appears to be a repeating violation of the county charter.
You need to forward your slides? The slides.
Thank you. And so the simple questions are, how many subdivision deferral agreements are there? This view on the screen shows just a small section of South Kihei Road. Each one of those circles is a subdivision with deferrals. Some of them, the sites are huge. Can they be collected on? What would be a real-world formula to use to collect on them? Those are basically the questions that the council just voted 9-0 to ask the independent county auditor to answer, because no one else has. Let's look at what took place on one oceanfront development along South Kihei Road. This will be an example. In 1984, the underlying oceanfront parent parcel was subdivided into 2 lots, and Corporation Council executed and recorded a 3-lot or less roadway improvement deferral agreement on the resulting parcels. In 2002, one of those lots was further divided into another 3-lot division, making a total of 4 lots. And it's not that the subdivision itself was a problem. Rather, the problem came when Corporation Council executed and recorded another one-time 3-lot or less deferral agreement on the second subdivision parcels. Not only did the overlapping subdivision not qualify for these deferrals, the overlapping subdivision triggered the 4-lot or more requirement. And roadway improvements should have been made right then to the frontage along the entire parent parcel. In 2005, Public Works Director signed off on yet another 3-lot subdivision, making it 6 multi-million-dollar oceanfront parcels. Both of these overlapping one-time deferrals were outside the director's authority and represent a complete disregard of the county's own ordinance. In 2001, Council member Joanne Johnson Weiner had already informed the director and the mayor that 4-lot or more requirements were being subverted using 3-lot or less deferral agreements, and the citizens were incurring the costs. Finally, in 2007, Johnson Weiner forced an end to the 3-lot or less deferral program. And I'd like to note that at that time, 26 parcels were grandfathered in. And though they have not yet been developed, they still carry the entitlement to do so and can still defer their infrastructure costs all these years later. This is also South Kihei. Letter K on the map is a massive development with enormous collective frontage involving acres and acres of homes that were all carved out from the same original 3-lot or less subdivision. Each and every home has a 3-lot or less deferral agreement recorded on its title. Here, letters X, Y, and Z show a commercial development along Lipoa with a mini storage and office buildings that was allowed to use a 3-lot or less deferral agreement. Notice how many parcels have circles over circles, which represent the multiple overlapping deferral agreements. All of these questionable applications in just this one area of Maui grew out of the 3-lot or less deferral ordinance, shifting tens of millions of dollars on both commercial and residential developer obligations onto us, the taxpayers. Phase 1, 2, and 3 of South Kihei Road, you see them here, have been completed. Phase 4 has been funded, and none of that has triggered the collection required by the ordinance.
There's more to our show in just a moment. This program is brought to you as a public service by Maui Causes. Maui Causes is a crowd-funded media production group that provides media production services to a variety of environmental and progressive causes here in Maui County. Visit us on the web at www.mauicauses.org.
How many different variations of deferral agreements has been written? There are 3-lot or less prior to 1990. There are 3-lot or less after 1990. 3-lot or less with multiple overlapping applications of additional 3 lots or less. 3 lots or less on countless condominiums. Single-family homes in planned developments that are huge. 3-lot or less in commercial and industrial zones. And finally, there's one application that we know of, and there may be many more, where a private attorney actually altered the 3-lot or less county agreement by writing a warranty deed, a private warranty deed, that added parcels beyond the 4-lot threshold. And they never gave any notice or got any approvals from the county or from the other subdivision participants. How can an attorney do that? How is that allowed, that an attorney can actually rewrite a government contract? So what happens as the county tries to start collecting on one or more of these different types of deferral agreements, as they are proposing to do on Hui Road F? This is where it gets thorny. Who do you collect from? Wouldn't the owners of the first layer of deferral agreements claim that the subsequent deferrals, which agreed to pay the future amounts, absolves them of the financial burden? Wouldn't the second say that of the third? Or would the second and third realize that in issuing these agreements, the county made a faulty decision and violated the one-time only stipulation of its own ordinances, and that would make these agreements unenforceable? That's reminiscent of Montana Beach, where the county vigorously defended a director's faulty decision and ultimately lost. A repeating story. Maui taxpayers ended up having to make the developer whole. How many Montana beaches are out there? How many overlapping multiple applications of one-time only deferral agreements are out there? In his viewpoint, Director Good wrote, "This is not a county-wide conspiracy. It actually boils down to a conflict between neighbors that has been ongoing for years." Well, the fireworks have really not begun yet because the county hasn't tried to collect on any of these. Just wait. They did once in 2010, and that has had disastrous results that are working its way through the courts still today, and why we have to be careful in how we talk about this stuff. As the director recently asked, if one of the lots is oceanfront with just a narrow driveway that fronts along a major roadway, while the other 2 lots front the county roadway completely, do these 3 homeowners split the bill in thirds? Or does the oceanfront owner with a property of obviously greater value just pay for the linear footage of their own narrow driveway, a flag lot? Are the neighbors supposed to haggle over how to determine prorated shares amongst themselves, as one director put it in public hearings? Where is the ordinance that lays out this dispute-living language? In 2014, Public Works Director wrote in his viewpoint, "The agreements state that if and when the County of Maui does a capital improvement project along a roadway frontage, fronting a property that has one of these agreements recorded against the property, the county may recover the costs of doing these improvements that were specifically deferred." That may have been true before 2010, but after 2010, the council mandated that all CIPs must trigger notices of intent to collect, which triggers the whole encumbrance transition to a lien debacle. Public records reveal that the impacts of how deferral agreements are managed goes beyond financial to include degeneration of our shorelines. Installing roadway and drainage improvements, storm drains, curbs, inlets, retention basins, these are all assessed as environmental protections under SMA Minor permits, but they are often lumped together with the work that gets deferred under a 3-lot or less subdivision deferral agreement, and the environmental protections never get installed. We believe this is actually a violation of the Federal Shoreline Management Act, which, ironically, the County of Maui is paid by the state of Hawaii to administer and uphold. Former County Council member Joanne Johnson wrote in a declaration in 2015, As I have been learning, and I quote her, as I have learned during the final years of my tenure as a council member, the planning department was not tracking SMA requirements that would ensure compliance of developers in completing their SMA roadway permit and drainage mitigations. They appeared to rely solely on the integrity of developers and complaints from citizens to administer developer compliance. I am deeply concerned that the SMA permitting process has become a means for private developers to skirt their infrastructure and environmental mitigation responsibilities, since enforcement may be absent or selective. We all see the impacts of this as we sit in traffic along the shoreline roadways. Is this an unethical manipulation of county ordinances that violates federal law and contributes directly to the degradation of our precious shorelines? Because we've seen no movement from the county to close these loopholes that are impacting the public and our environment, Maui Causes recently initiated a public petition that also calls on the county's independent auditor to assess the losses to the public from both deferral agreements and SMA permit application fraud. Yes, fraud. We've got 1,750-something signatures represented here. At the council's request, we would be very happy to make a separate presentation on how SMA permit fraud works. Let me underline that again. Fraud. Looking forward, there are some silver linings manifested in all of this once we tackle the hard realities of this sobering history. Let's look at how to put an end to this mess, admit our oversights, and repair the injuries that we've all suffered. First, the council and the public needs a sample of each of the different forms and applications of deferral agreements that Corp Council has executed so the entire playing field can be evaluated as a whole. Second, each individual form of agreement needs a legal determination as to its enforceability and collectability. Third, we need a legal opinion as to whether collecting on one form of agreement or not constitutes selective enforcement, which would force the forgiveness of them all. Fourth, we need a determination as to whether an agreement can be collected on if it relates to a CIP that has already been completed, or if the county failed to collect on prior phase of a roadway, can they be collected on the future phases? Fifth, if the agreements are deemed uncollectible, we need to establish a database. If they are deemed collectible, rather, we need to establish a database, boundary maps, a formula of assessment for each type of deferral agreement, a process of proper noticing and collection, and the removal of encumbrances to the affected parcels. Sixth, if the council determines the collection and assessment process will lead to overwhelming disputes between property owners and repeated legal challenges, we need to swallow our pride and expunge them, and all look to apply the lessons that we've learned going forward. Seventh, as a council, while the immediate legal review is taking place, we can make sure that we don't repeat these errors by adopting legislation to ensure that every future development pays their fair share of roadway infrastructure. We should look back at legislation that was shelved at the direction of Corporation Council in 2012, which provided concise solutions to accomplish these goals. For example, if the frontage lies along a roadway without an adopted plan, we can collect a fee in lieu with district-specific accounts like park fees. We can avoid the legal challenges that could stall any new roadway projects by replacing the questionable island-wide upcountry water bill 2-lot or exemptions. Replace that also with a determined fee in lieu. We can avoid millions of dollars of waste by ensuring that capital improvement projects are shovel-ready before approving funding. What this means is that the overall plan has been presented to the public and adopted by the council, and the land rights along the roadway frontages have been negotiated and secured before final drawings are made. We can amend the county code to ensure all developments, including condominiumizations and re-subdivision and consolidation of ag subdivisions, are all treated the same. For example, the overlapping splitting of land ownership through condominiumization of ag lots should be treated the same as other land subdivisions. It's currently not. Condominiumization of ag lots is a total giveaway. The county is being raped. We can eliminate the ongoing park fee exemption for 3 lots or less and provide relief for subdivisions processed under the family subdivision ordinances. For example, oceanfront subdivisions and resulting multi-million-dollar residences should not receive ongoing exemptions from paying their fair share of park fees. Why are we giving that away? We can amend Title 18 of the Maui County Code to ensure that SMA permit environmental mitigations are implemented into the roadway engineering plans and completed as assessed and not deceptively discarded, deferred, or exempted. We can amend Title 18 of the Maui County Code to ensure, as most municipalities do, that all order of magnitude estimates created by development consultants for the issuance of SMA permits are signed off by engineers in public works for their accuracy and to ensure that they have not been purposely underestimated to avoid public review and environmental assessments. Maui Causes seeks a positive and urgent change, and we hope this presentation aids in that purpose on these issues presented today. Thank you so much for your time.
Thank you, Mr. Small, and that was a lot to take in.
You think?
And digest.
I can
We're
make my
following
script
off.
available.
That way, I mean, they can refer back to a lot
Absolutely.
of stuff that you
It's a pretty
spoke
good
about,
primer.
because there's a lot there.
Yeah. I would hope that you would do so. That's
And
great.
yeah, that was a lot to absorb, just listening.
And as we turn the SMA corner, there's even more. So
Yeah.
that's a whole separate presentation.
Right, and we can jump into that another day. Ms.
So
Sugimura.
just curious, I don't know Mr. Small personally, so what is your credentials to give us all this data?
Yeah, I'm a documentary producer. I have been making films on complex subjects since the 1980s. I've produced and directed documentaries for the New York Times, for AT&T, for Fidelity Investments, for Prudential Financial. And I was the media director for the Shaka movement here on Maui in 2014 and directed the media campaign that won that election. And since that time, I founded Maui Causes as an ongoing community education entity. I have a weekly show on a kaku. Many of the county council members have appeared on my show.
I'm just curious. I can tell you, I think when I saw you outside of this chambers, you mentioned to me your Akaku show. So, and I know I've seen you testifying here on various issues that have come before the council. And I was just wondering, do you have a legal background to gather all this information?
I do not have a legal background. I have a journalist, a background in journalism. So I understand fact-checking and being able to go through deep, rich content and present it in a way that is fair and balanced.
And the information that you presented, I guess when we receive your testimony or your speech, you'll have footnotes so we can double-check, fact-check your facts, because they sound pretty heavy-duty.
I can provide footnotes for everything that's in there. That work, it took me 10 days to verbalize this presentation in the form that you see it, with a very rough graphic presentation that goes with it. But I can provide that additional foundation. Nothing in here is made up. Everything here is substantiated by public records. And public statements, either by council members in sworn affidavits by county council directors in public statements that they've made to the press, or in council testimony, verbiage taken from minutes of council testimony.
So I noticed some of the names that you use are former council members and probably a lot of agreements that happened before we got here. But
that's kind of why we're going through all this, because we know that many of the current council members have not had the opportunity to digest this information. 5 years ago, through council deliberations, much of this material was covered 5 years ago, and then nothing happened.
So I'm just curious, what do you think about Who You Roll F that we just discussed, based upon your presentation?
It's a challenge. There's no question. As many of the development issues created in Maui were done just simply to get by. One planning director called it a culture of leniency, where if you come up with a project, the county will just suspend its rules and allow you to do your project. If you can sneak under the radar, you can do that.
Ooh, that sounds subjective. I don't think that's a fair statement.
Well, we have documentation. I have documentation to show. I mean, when we get into SMA permits, I can clearly show you fraud and loopholes in the process.
So, Chair, I've had enough. I don't think it's fair for him to come here and call this body fraud or make these kind of accusations. So,
I understand your hesitance, and I respect that.
And we can move on.
So hang on, Mr. Small, hang on. So just for reference to this entire body, everything that's in this PowerPoint, every word, well, there's a couple words, Mr. Small, we didn't approve through my office. So majority excluding, I think, 2 words, and this entire script that he has was vetted through my office. We made sure that he stuck to facts. We made sure that he didn't impose his own opinions or thoughts or his take per se on things. This is all documented and backed up by quotes, facts from letters that were actually handwritten. If it was a quote from Public Works, it was written in a viewpoint by David Good. If it was a letter sent to my office via David Good, if it was something Milton Arakawa had said back in the day, these are all from minutes of different committee meetings. Things in this are fact checked. I made sure I was not going to present something here that was just some airy-fairy off some guy's top of their head. Okay, so just so everyone here knows, that's what this presentation is about. There's nothing fluffy or anything of that nature here. So it is facts.
Okay,
and as you can see in the PowerPoints, he has actual news clippings or points that he pulled out on actual maps from our system, actual minutes from our system, all this stuff. This is not hand-drawn. This is actually printed legal stuff. So that's what's presented here. So I kind of don't understand why your sense is it's just Mr. Small coming up with his own,
I was just trying to justify his background and hearing the word, calling fraud or whatever for past council members. I'm just trying to stand up.
Not council members.
Or the county.
So the overall gist
licensed professionals
is backed up. The general idea, and again, there's a lot of information with these deferral agreements. Obviously, they've been going on for decades, and there's something that has occurred, and there's never been any follow-up. And we're trying to get to the bottom of it. I mean, trying to figure it out. And the bottom line question is right now. I mean, Ms. Johnson Weiner had said she had enough, and she said, let's stop this program, let's stop this process. But what about the people who are in the process, who got signed into this program, this 3 lots or less deferral agreement? What about all those people? We collect, what about all the CIPs that have been done and paid by the taxpayers, and we never collected on the people who were supposed to pay in? What about that? I mean, there's so many questions out there, and there's a lot of people, and I know people in this room frustrated with, they're stuck in this, and it's not fair. I don't have the answers, but I'm just hoping that we can sit together and put our, you know, creative heads together and try to figure something out. And this is just the start to try and sift through what is this really about and what are possible solutions that can surface from all this discussion. But it looks like, Mr. Carroll, you have something you want to share.
Thank you, Chair. Yeah, I look forward to hearing this again, and obviously we're going to need Public Works here, Corporation Council, Planning Department, obviously, and also Public Works is going to have to be involved in that. And I would hope that perhaps could forward this to them and before we ever have that meeting, so they would be prepared to come and make comment at that time with possible solutions. Thank you.
And I know that Mr. Good had something to do, but he said he would monitor us and see what we're talking about. So I know the different departments are very curious, to say the least, and very interested in what it is being said here at this particular meeting about this specific item. Again, there's a lot to take in. There's a lot to you know, decipher and figure out, but it's something I think that cannot just be ignored anymore. And there's a lot of money that has been expended. There's a lot of money that stands to be received of the taxpayers and our, you know, our coffers here to this county, and we need to figure out how we're going to do that in a very equitable, fair manner. Because some people's lives have been disrupted very badly and negatively because of these, and others skated away, you know, so that is not right either. You know, I mean, Mr. Small, I want to thank you for your 10 days of vetting through. I know volumes and volumes of information, and you did it the best, you know, way you felt possible to bring this type of information forward, to wrap our heads around it, and hopefully the departments also that are involved and the public. So I want to thank everybody. But Mr. Atai, you had something to share?
Yes, Chair. Thank you. There's this page with all these graphs and then got some red question marks. What's all that about?
This is a county record acquired through the Kiva system. And it is a review of the permits and various different approvals of a SMA Minor permit through its process. And it relates to my use of the word loopholes. Because the tangible loophole is represented by those question marks. What could be filling those boxes would be the planning department's receipt and acknowledgement of the engineering drawings for that parcel. The county relies on licensed professionals. So if you make a permit application for an SMA, there's an order of magnitude statement that goes with that. And that covers all of the infrastructure work that is supposed to get done. And in many cases, that includes federal mandated shoreline protections. That process gets handled by the engineers. The resulting, and all of that stuff gets added to their drawings and their plans. None of that gets transmitted back to planning. So planning doesn't know if the work was ever actually performed. They don't have anything to compare it to. They don't have anything to look at. They have no records of what the applicant was supposed to do under an SMA minor. That's why achieving an SMA minor is so attractive, that a licensed professional would be willing to commit fraud to get one, because this loophole allows them to avoid doing the infrastructure improvements. And nobody knows. Planning doesn't have inspectors. They don't do a final inspection. Only if the public steps forward and draws attention and questions a developer. Oluwalu is the perfect example. It's the poster child. Oluwalu, this is what they did. Planning never knew that that developer skirted doing their environmental mitigations. And so for 10 years, we had uncontrolled runoff from Oluwalu until a citizen stepped forward and made a complaint, filed a complaint. And that triggered bringing back the developer 10 years later to fill in those question marks. And this is a systemic loophole in the county's structure that desperately needs to be plugged, because it's not historic. This is ongoing harm. This is being done today.
Okay. It's very difficult for us to even address this even further without departments present, so that we can allow them an opportunity to address that. What's stated on page 15, no one ever tracks not only deferral agreements, but also the SMA minor permits. I think department should be present for us to address this.
I'd like to get more members present also to get on the same page and table as we are, to really vet this through. It's just an ongoing issue, and obviously from the Joanne Johnson days, my predecessor here, that's been trying to work through this and wasn't able to accomplish it in her 10 years. So hopefully we can try and get some kind of foothold into this issue and start making some headway forward. But again, thank you, Mr. Small, for your work, and you have some suggestions here, and thank you for really conferring and following up with my office.
This program is brought to you as a public service by Maui Causes. Maui Causes is a crowd-funded media production group that provides media production services to a variety of environmental and progressive causes here in Maui County. Visit us on the web at www.mauicauses.org.